Okay, so chapter 5 is about making a contract, and I wanted to go over a few things on this chapter because I think there's some really important things that I think you guys need to be aware of. So here are our objectives for this little lecture, and it shouldn't take more than 15 minutes, but you guys can look through the objectives, but we'll try and cover all these in this short little lecture. I am going to encourage you to review the vocabulary in Chapter 5. I think there's some really important, and we're going to kind of cover it a little bit in this lecture, but definitely take a look at the different vocabulary for Chapter 5. So some general information about contracts that you guys need to know, just some words and terms that you can think of, but I don't think people realize that when a patient and a physician form a relationship, it is contractual. And the reason why is the physician is agreeing to do something and the patient is agreeing to pay for those services. So in a physician-patient contract, it is a voluntary agreement between two or more parties that establish legally enforceable obligations. So the physician's obligation is to treat, diagnose the patient, and the patient's obligation is to pay, either a deductible, copay, whatever. So a lot of these contracts can be expressed orally, they can be written, or a lot of times implied contracts, which is just by action. So when we go to the physician, we don't really sign a contract, but we do, sorry, my cat was on me. We do often show actions or orally agree by just showing up to our appointment. So a few things that you want to think about when you're looking at contracts is words like breach, which is one or more of the parties failed to perform one or more of the terms. So we're going to talk a little bit about that. And then when you do have a contract in healthcare, these are some types of healthcare facilities that can have contracts, such as insurance companies can be contractually obligated. Leasing office space is contractually obligated. Employment, so employee-employee relationships. You can have contracts with other healthcare facilities. And then also when you work in a physician office, you can often have contracts with clinical laboratory services, medical record software, other things like that. So often a lot of these patient-physician contracts are mutual agreements, and it's a clear understanding between the two parties that they are planning on forming a contract. So that's just a little bit about contracts. We do implied contracts or implied consent quite often, which is kind of like implying that you're going to go under the care of that individual. So a physician contract are typically implied, and there is things that are called like curbside consultation, physician communication via phone. There are a few things that can get a little dicey, and there's a couple case studies, or actually not really case studies, but court cases that are listed on page 114 and 115 of your book that talks about some of these scenarios. And I really liked the one on page 114, and I'm going to read through it to you, and I want you guys to kind of think about this. So this is a result of the start of a patient-physician relationship. It sometimes can be unclear in certain situations involving like on-call physicians or specialists or informal consultations with colleagues. So a lot of times they call these curbside consultations, or physicians who are covering for another physician who's like on vacation, or even like think about an ER physician. Okay, so this case was about a patient who presented in the ER with 3 days of headaches, and after examination and observation, the ER physician decided that the patient should be admitted to the hospital, which, based upon the patient's health care plan, required approval from her PCP, her primary care physician. So the ER physician briefs the PCP and recommends hospitalization. But the PCP doctor did not approve the admission and directed the patient to be treated on an outpatient basis. The patient was sent home and suffered a stroke a few hours later. The patient sued and alleged, in part, that his healthcare plan created a patient-physician relationship by contract. And the court agreed in part because of the healthcare plan obligated its contracted doctor to treat the healthcare plan member as they would treat their own patient. The patient had essentially prepaid for the medical care of his PCP and the healthcare plan doctor on duty that night. So, unfortunately, even though the ER physician wanted to admit the patient, both of the physicians were held liable because it said in his healthcare plan that an ER physician, or even though his concern about paying, he still was covered underneath because it was a referring physician. So it can get it's really not black and white. It can be really, really gray when we're looking at laws, and it really depends on how the judge will see that law. So there's a few other cases that you're welcome to read on page 15 that kind of covers that. But one thing is to remember that a physician, just like a patient, a physician can refuse to treat a patient, and a patient can choose to go get a second opinion, and they can break that contract. So, for example, a physician can refuse to treat outside of a particular specialty. Maybe they're not comfortable with it and they can send them somewhere else. They can refuse to make house calls, which doesn't sound unusual, but back in the day it was very common. They can refuse to treat patients on the phone. That's why typically when you call a physician office and you get the answering machine, they say if this is a medical or emergency, hang up and call 911 or go to your nearest emergency room. That's why they do that. They can refuse to extend their office hours beyond. So, if they want to work 8 to 5, they can work 8 to 5. If they want to work 12 to noon, they can. They can close at lunch. That is their right. They can refuse to not accept new patients. They can say, I don't want to take any more new patients. So if a new patient walks in, they can refuse them. They can refuse a patient on a particular health insurance plan if they don't want to use it, like Medicare or Medicaid. They can refuse a patient that cannot pay, because then they're not contracting, because they're not giving their part. So they're really kind of in breach of contract if a patient doesn't pay. And the patient with a medical malpractice attorney in the family, they can refuse a patient that has a family member that's in medical malpractice attorney, which I thought was kind of interesting. So they do have the right to refuse patients. So acceptable parties, like who can actually become part of this contractual agreement between physician and patient? Well, there are a few exceptions, and a couple of them are legal disability. People that suffer from a legal disability, it is authorized to act as a representative in the contract. So the contracting party does not have a legal disability. As long as they don't have a legal disability, they can contract with them. But if they do have a legal disability, they can choose not to, and it really comes into play when we're looking at, are they competent, and what is their disability. So a person with a legal disability cannot form a contract, because a contract cannot be made or enforced against a person who does not have the legal capacity for mutual agreement. So you got to think about, like, for example, the woman who was in a coma. I know her family put her in that situation because she was younger originally, but as an adult, she can't form a contract with them because she can't communicate. The others are minors. Minors cannot give consent. Medical practitioners can be held liable if not given consent to treat a minor by a parent or legal guardian. It can be considered assault and battery. So they have to have consent from a minor. There are usually a minor, it's the age of majority is what they call it. In most, it's state to state, so every state has a different one. Most states it's 18 or older, but there are a few states where the age is 19 or 21. And unless the minor is emancipated, meaning that they have accepted their medical emergencies, or they're mature enough, and they have to go through the court to get emancipated by their parents. but other exceptions of state that allow minors to obtain are birth control, prenatal and sexual transmitted disease services without parent involvement. So you don't have to be emancipated from your parents if you need birth control. You can go at the age of 16 and get birth control, and it does not have to be communicated with your parents or legal guardian. Prenatal care or sexually transmitted disease treatment. So those are some exceptions to the rule. So abortion is kind of a tough one because now it's changed. It used to be federally legal to have an abortion, but now it's no longer upheld by the federal government, and it has been given to the states. Abortion's always kind of been controlled by the states, but because the federal government said abortion was illegal, if a state wanted to say it was illegal and the federal government said it was legal, the states couldn't do that. They still had to honor it, but they could make some clauses in there like, we are not going to give it past this term. They could do that type of stuff. But now that the federal government is no longer upholding abortion, the states have more control if they want to allow it or not. So even with the new changes regarding abortion by the federal government, some states that have made abortion legal requires parental involvement in the minor's decision to have an abortion. So most states do have that in place if it's legal. In a lot of states, there are some states it's not legal, like Texas. But if you went to New York, abortion is legal. But a lot of those states still require parental involvement for an abortion to make that decision. Now, other contracts, there's a principal agent contract, which is referring to employer and employee. So, for example, a lot of times in medical practices, the employer is the physician and the employee is like the medical assistant. The termination of contract, you can terminate a contract for any reason, but satisfied patient. So basically, you go get your services from your physician, everything worked well, your physician treated your disease, you're good, and it's concluded, so you're done. Mutual termination, like, okay, well, we don't want to, maybe they want to send them to a specialist, and they're like, okay, well, I'm going to go to this physician that mutually understand, and they move on, and that contract is eliminated. If a physician chooses to stop the contract with the patient or no longer treat the patient, they must do it in writing. It's usually a written notification, and I think there's a time frame. They have to submit it by so many times. I'm going to give you guys an example. My family practitioner, my PCP, they decided to sell their practice to Village Healthcare, and they moved away. And so over the summer, this happened over the summer, and they sent us a letter in the mail saying they will no longer be treating us as their PCP. So we had to find a new PCP. So they notified us that they're going to no longer uphold their contract. And patients can choose to break their contract by just seeking another doctor or other care. So breach of contract is when one of the parties doesn't keep their promise. A patient doesn't pay would be an example. A physician isn't performing, not keeping a schedule, not doing a procedure. Those are breach of contract, and they can be admissible in court. Abandonment is when a physician gives up completely or deserts the patient and implicitly indicates that the physician intends to terminate the contractual relationship. And all of these situations, anything under medical malpractice can fall under a statute of limitation, which is a length of time that a person has to file a lawsuit following an injury. So if you feel like there is a malpractice, you need to know what the statute of limitations are, because after a certain amount of time, you can't file a lawsuit if you think you should be able to. And then advanced directives, which I think you all have heard of. This is a living will or a healthcare power of attorney where you write a living will and you designate someone as your power of attorney. There was a law in 1990 called the Patient Self-Determination Act, which required all healthcare facilities to provide written information to each adult admission regarding patient rights under state law to make an advance directive. So it was basically trying to encourage everybody to have one in place just in case of something happening. So that's kind of chapter 5. It's pretty short and sweet. I'm going to show you guys the lesson here that I want you guys to do, but I wanted to give you guys this case study because I thought it was kind of interesting. So a 16-year-old female was pregnant and wished to get married to give the child legitimacy. Her mother objected strenuously and took her daughter to a gynecologist to have an abortion. The gynecologist refused to enter into contract to perform the abortion without a court order. Should the court allow the abortion? So I'm going to leave it at that. I'm going to leave that question right there. And I'm going to post a text box response called case study, lecture case study. And that's going to be your assignment. I want you guys to respond what you think. And then once you guys respond and submit your answer, I'll probably do it as a quiz. So I'll have you guys submit your answer and then you'll see the actual answer of how it was supposed to respond. So being what you learned in this chapter 5, should the court allow the abortion and kind of why or why not? And that's all I have for tomorrow. So stay safe and hopefully this will help you guys get through chapter 5.